Ladies and gentlemen, I'm Devanshi, your host for the session today. Good evening and a very warm welcome to the WebEx session on augmented reality, virtual reality and mixed reality, navigating legal and tax issues. This session will be presented by Huzefa Tavawalla, Meyyappan Nagappan, Inika Charles and Abhishek Senthilnathan from NDA. Please note that this session will be in listen-only mode and will last for about 60 minutes, of which first 30 to 40 minutes will be spent on panel discussion. The remaining time will be available for question and answers. We request all our participants to post their questions in the chat window. The moderator will queue up the questions for the speakers accordingly. I request you to keep writing the questions while the panel discussion is on. Should you need any assistance during the conference call, please use the chat option. You may also note that this conference is being recorded. Lastly, but importantly, all the participants are requested to put their phones on silent mode while the panelists are speaking. I now welcome our session presenter, Huzefa Tavawalla, leader and head of our Disruptive Technologies Practice Group, and is based out of our Bangalore office. Our other panelists are Meyyappan, leader of our Impact Investment and Social Finance Practice Group. Inika is a member of our Technology, Media and IP practice. Abhishek is a member of the Technology practice at NDA. I would now request Huzefa to take over the session. Thank you.
Thank you. Thank you for the kind introduction, Devanshi. At the outset, good morning, good afternoon, and good evening to all our friends, who have logged on for this session across the world. I think what better time to run this session on augmented, virtual, and mixed reality because of these testing times where the real world has actually become virtual and the virtual has become the new real. To be honest, with times such as these, you actually realize the importance of the internet and how effective, things can be done virtually. Having said that, with the passage of time, augmented reality and virtual reality has only enhanced. Initially, things which were meant only for entertainment and recreational purposes have been used now as effective business drivers. And it's not any centric to any particular industry. It is industry agnostic. In fact, moving forward from the entertainment industry, augmented reality and virtual reality has segued into the retail markets. It's segued into the medical stream. It is also segmented, into certain industrial applications. So the user enormous, the technology is there, and we are at the right time and the right place. So with this note, I think let's just get into and dig into our session. And at the outset, I would like my colleague Inika, just to give some inputs or throw some light in terms of, where does the AR, VR, and mixed reality seem to be emerging in, which are those industries? Over to you, Inika.
So just to begin, I'd just like to distinguish these three technologies and what exactly they encompass. So they're very much what the name suggests. They show us a reality different than the one we're in right now, and in different ways. Augmented reality is an interactive experience that places virtual elements in our real world using technology that's more often than not our smartphone or our smart devices. And an example of that is, the very famous Snapchat filters or the Instagram filters that overlay certain elements on people's faces. And another very popular example that came to light a few years ago was Pokemon Go, where you were able to point your phone camera at different locations at this desk where I'm sitting at right now, and a Pokemon would appear on my screen. And that's the best example of an overlay that AR is. And virtual reality is a completely simulated experience in comparison that transports the user into a completely different world, and it's very widely used in especially video games today. So virtual reality necessarily comprises of a headset, and a number of manufacturers have gotten into this right now. Facebook's Oculus or HTC or Google Daydream, they've all come out with headsets that now various games and applications can be played on. So the minute you put it on, you're transported into a completely different world. And like Huzefa was saying, that these are finding these technologies along with MR, that is essentially AR 2.0, which is a hybrid form of augmented reality where the physical and the real objects interact. So Microsoft just launched something called Microsoft HoloLens, which is the best example of mixed reality that we have today, which is a headset that you put on and it projects certain virtual images that you are able to move, touch, play around with. So that is the best example for mixed reality today. And various sectors are taking these three technologies and using them. Like one great example is gaming, another social media, travel and tourism. Now that we're all grounded at home, are widely using AR, VR to transport people to different locations. The retail industry, the healthcare industry, they're all now making use of these technologies to better service the consumer. That over to Huzefa.
I think that's a great kickoff to this session, Inika, especially how you've explained in terms of the industries it would apply. Just so from a user perspective, just to kind of summarize, uh, augmented reality is digitization in the physical world. So your physical world exists. The only change is there are certain elements of digital brought into the physical world, whereby when it is virtual, which is VR, virtual reality, the world is completely digital. There is nothing physical. As Inika said, it's a simulated experience. And mixed reality is a culmination of both to enhance user experience. I think with this context setting, I think it would be very appropriate right now to move on and discuss. Are there any sort of issues which are faced specifically when it comes to intellectual property? And more importantly, the sense of intellectual property is ownership. So probably Abhishek, if you could throw some light on, what sort of issues come up, from an IP ownership perspective within this industry.
So broadly, I think while we're looking at the kind of issues that come up with regards to ownership, I think we can club it or talk about IP ownership in three different sort of tangents. So the three tangents would be from the perspective of copyrights, from the perspective of patents, and from the perspectives of trademarks. Now, firstly, dealing with copyright. Now, copyright is the most common form of protection that's generally can be availed in relation to software programming or in relation to computer codes. So, under the Indian Copyright Act, a wide variety of works as such can be afforded copyright protection. Works such as literary works, artistic works, musical works, or even cinematographic films. Now, generally, when it comes to computer programs, the most common form of protection that's availed in relation to computer programs is in the form of literary works. And that generally applies in relation to the base code or the software code which goes into setting up the entire AR and VR portal or the program. And when you talk about literary works and computer programs as literary works, what the Indian Copyright Act says is that the person who has created the work, who is most closely associated with creating that particular piece of work or that code, would be regarded to be the author and the owner of that particular literary work. Now, in the case of computer programs, and especially in light of AR, VR, and MR sort of portals and sort of offerings, the developer or the actual programmer beyond the code is in a general scenario regarded to be the actual initial author and owner of the code itself. Now, however, there's a few more intricate complexities when it comes to copyright ownership, especially in AR and VR. AR and VR can be looked at in two elements, where the first sort of aspect of this is where it's generally used with video gaming. Now, how video gaming parameters work is there is a preset code that's set up by the developer where your video game would work in those identified circumstances where a player moves from point A to point B without having much control over what other actions they can take within that environment, and with a preset set of coordinates that are already built into the program itself. Now, in that form of an augmented reality or a virtual reality used in video gaming, it can be said that the programmer is directly or closest in control over what's actually happening with the final product. And in that sort of scenario, the initial author and the actual owner of that product can be regarded as the programmer itself. Now, however, there are a few different ways in which AR and VR is used, where there is a completely different reality created by a virtual reality product, which allows the user or provides the user with freedom to function in any manner as as they choose and take any actions as they want. Where in an alternate universe, there is no set standards or a set path that the user has to take while they're using or walking through that reality, and they can make decisions on their own. Now when it's such a scenario, there is a possibility that if the user takes certain actions and puts out certain products or something actually results out of the user's action, under copyright law there is also an element where it can be said that the user has put in their own skill and put in their own hard work to sort of bring out a different output from the base program itself. And in that scenario, these developments would be regarded to be owned by the user, and the user also may be regarded to be the author and the owner of these sort of separate developments under Indian copyright law. Now, why this is a little bit more critical when it comes to AR and VR is what we normally see is the only contract or the only arrangement that a developer and a user has in these scenarios are the standard form terms of service. And in most of the cases, the terms of service set out that anything and everything that the user creates or develops or anything that they carry out while using that platform or the portal would automatically belong to the developer or the owner of the software or the owner of the portal. Now, a very important intricacy to take note of in this situation is when it comes to copyrights, and especially in the scenario where a user has developed or created something themselves within that virtual reality. Indian copyright law requires that in the case of an assignment of a created copyright, there needs to be actual physical signatures by the assigner of the copyright in order for the assignment to be valid. And generally, when it comes to terms of service documents as such, the most common form in which we see them are in the form of click wrap agreements, where all you need to do is accept the terms. And also consider this, especially that people need to keep in mind when they're trying to obtain an assignment of these rights. Now, from a copyright perspective, these were the ownership sort of aspects and issues that may be there. And moving on, secondly, to patents. Now, patenting also is a very important tool that's used commonly by AR and VR developers when it comes to such portals and products. Now, under Indian patent law, a computer program per se by itself is not patentable. There is a requirement under the Indian Patent Act that in order for a computer program to be patentable, one, it needs to involve an innovative step, and two, also it always needs to be in combination with a particular, let's say, commercial output or an actual sort of hardware product which is combined along with the software, which provides an overall sort of single product that has a combination of both. And sort of element under Indian patent law is beneficial to AR and VR products is the most common form in which all of these products are launched or they're used is there is programming that goes into an object such as a VR headset or an actual hardware product within which the software is embedded, and both of them used together provides the final output, which is the AR or VR portal. And because of this combination and because of the skill that's involved in combining both of these together, and because of the different look and feel that you sort of receive when you access the AR and VR portal using both of these elements together, patentability of these portals, is more of an accessible in a sort of easier form of protection. Now, this is also can be evidenced by seeing that in the recent past, there have been instances in India of AR and VR products being granted patents by the Indian Patent Office. And a recent example would be Google receiving a patent in the past few months for an reality product that they launched, which allowed users to add specific tags onto actual buildings, which can only be viewed by people that they identify within the product as in when they log into that portal or that product. So this was an element from the patenting side of things. And just quickly touching on trademarks, just to spend 30 seconds on that, a common sort of issue that may crop up, which we'll be going into in more detail, is the usage of brand names, logos, an actual trademark within these AR and VR reality products themselves, and the issues that may arise with this, where if the most common example may be using the branding of McDonald's, where you have an actual offering inside the virtual reality which is offering food, and you have a trademark which is somewhat similar or which resembles the actual branding or trademark of McDonald's in itself. How these may be issues also is another concern that needs to be looked at, and I think Huzefa might be sort of going into a little bit more detail on that. So yeah, I think over to you, Huzefa.
No, I think Abhishek, you have summed it up really well. I think what is directly akin to ownership is the most obvious next in terms of infringement, right? What you can do as a owner, and if you're not authorizing somebody else to do certain things, then can it amount to infringement? So I think in the AR, VR, MR world, these lines get very gray. Because there are no set rules to play, and it's not those traditional principles of law which apply. So concepts such as fair use, derivative works, contributory infringement get extremely interesting. So just for an example, right, a lot of these VR environments are very interactive. To give you one such example, some of these games actually permit the user to actually take images, graphics from third parties, which is outside the game, kind of embed it and give them the right to develop a particular character or to enhance the environment of the game. In fact, some games give the user the right to actually identify his character in his own style or in his own manner, depending on look, height, body, feel, touch. Various permutations, combinations are there. Now, obviously, the platform which is offering such products, such games, or such devices, the contract disclaimers would obviously be there, whereby any sort of liability, IP liabilities would vest with the user. But having said that, the jurisprudence is still evolving, that to what extent can the platform be held liable? Yes, there are certain principles of intermediary laws if in the case where the augmented reality or the VR is just a platform and it is not a device. It's a digital simulation which is connecting two pieces. But even in those cases, to what extent can the AR VR entity or the platform which is offering such services, can they actually amount to contributory infringement, because they are facilitating the entire ecosystem, and especially if they are charging some sort of a fee to the user, their skin in the game kind of increases. The other area which is really gray is the trademark usage. I think Abhishek very briefly spoke about that. And I think more akin to trademark usage is the doctrine of fair use, which is actually an exception to trademark use. And these are the general principles of trademark law, which are globally followed. And more so, I will just give a brief when it comes to India. So just let's look at a situation that today in a game, which is actually programmed, or a VR environment which is actually designed, there is a lot of references of real life trademarks. Like it could be a food brand, it could be a travel brand, it could be a merchandise brand. There are various brands. Now, at no point in time is the platform attributing its goods and services towards that particular trademark. In a sense, it's not trying to deceptively confuse or deceptively cheat the user of the game. But having said that, the entire objective of fair use, the doctrine of fair use, gets defeated if the usage of the trademark is such that it is detrimental or is providing disrespect to the actual owner of the trademark. So in an environment, if it's like if the AR VR is a violent game, for example, and there are some sort of placements of trademarks, now the trademark owner may actually not want its image to be seen in such an environment, and it can say that the doctrine of fair use may not apply. Having said that, the jurisprudence is extremely interesting. It is exciting, and I'm sure it will evolve over a period of time. So these are the issues which typically come in such scenarios. But I think we'll discuss more and more as we go, and especially the interplay vis-a-vis IP and liability from a consumer, from a product liability, from a tort perspective, which we'll discuss in a few minutes. But I'll take a pause there, and I think since we've discussed ownership, since we've discussed infringement, the other related question which always comes up with these two what about privacy, right? Now, a lot of these platforms, a lot of these models actually function on user data, user feed. That is, the as good the data, as good the interaction is. So at this point in time, it would be great if Inika can come in and Inika, basis your experience, these technologies have a lot of user data. So in such scenarios, what are the privacy concerns which you usually see, factor into?
Thanks, Huzefa. So I think we can look at the privacy concerns from two different angles, one from a user point of view and one from the point of view of the developers of these AR, VR technologies. From a user point of view, it's important to know exactly what data you are giving to a developer, and it's important to know how they're allowed to use it. And the important thing to do would then be to read the privacy policy, to read the terms of use, to read any contract that you are entering into with the developer, where all these uses and purposes would be charted out. So, for example, when you accept terms on your phone, there are some apps that track your location all the time, and there are some apps that track your location only while you're using that application. And you have these options. So, from a user point of view, it just boils down to awareness and how many permissions you're willing to give an app. From a developer point of view, the considerations to be kept in mind are from the data protection law that is applicable to you at that point of time. In India, the current data protection law at this moment only prescribes um, obligations on developers, on companies that collect sensitive personal data, which include financial data or health data. But as some of you may be aware, there's a new draft pending in Parliament as called the Personal Data Protection Bill 2019, which, if it's enacted as per its current draft, will regulate not only sensitive personal data, but all forms of personal data, including a name and email address, and the compliance obligations that currently are only for sensitive data would be triggered even for the collection of such kinds of data as well. So from a developer point of view, especially if the proposed law is introduced as it is, there are certain compliance requirements that need to be kept in mind. The first would be that you need to give notice and take consent from users for the collection of data. The second would be that the proposed law, the PDP bill, does have extraterritorial jurisdiction in some circumstances.
Inika, one
Sorry, I
minute.
think someone's not on mute.
Yeah, I was just about to say that. Please, people, request everyone to put your phones on mute, please. Thank you.
Thank you. So what I was saying was that the proposed law, the Personal Data Protection Bill, does have extraterritorial applicability in a few instances. So if there are AR, VR developers who are based outside the country, the law would be applicable to them as well, should they satisfy certain tests as prescribed under the law. So should they be seen to be carrying out business in India or systematically offering goods and services to those in India, then the law would apply to them, and then these compliance requirements would become important. Another consideration to be kept in mind is that these AR VR games are often played by those under 18. And as per the proposed law, anyone under the age of 18 would be qualified as a child. And if you are a child, if you're under 18, then developers need to first verify the age of these children, and second, take parental consent for the collection of children's data. And there are certain other considerations, like if the products are seen to be directed at children, there would be certain special obligations that may trigger, but that's one consideration to be kept in mind. The second is that the proposed law calls for privacy by design to be adopted by data fiduciaries or controllers, as they're known as under the GDPR. And developers would have to keep this in mind while developing these technologies. And the last point that I'd like to touch upon is anonymized data. So a lot of these technologies actually collect anonymized data, run on anonymized data. And while anonymized data per se would not be governed under the proposed law, the current draft has a provision under which the government has the power to direct these developers to provide any such non-personal or anonymized data for certain in certain situations and for certain requirements. And this is also something that developers who run on anonymized data would have to keep in mind. Back to you.
You've summed it up really well, Inika. I think privacy laws across the world are evolving. I think with the advent of GDPR and a new PDP bill, right? I think the immediate nexus of privacy is for what the information was collected, and more importantly, it cannot be used for anything else. Now, of course, the underlying principle will always be that if you've consented to it, and if you've gone and consented beyond the use, what will happen? And as you rightly pointed out, that under our proposed law, there would be certain challenges, with a blanket green signal where the developer or where the platform can use the data for everything. I think more importantly, what will also happen in a VR, AR environment is that data is collected across the world. So there is a lot of cross sharing, not only between a particular user and a developer, but it is at a real time simulated basis from multiple users. And then there is convergence. So there is, to some extent, there is machine to machine interaction. There is, to some extent, there is an Internet of Things which kind of circles in. So all of these concepts, specifically when the developer is actually assimilating data, big data, mining it, how will it actually pan out from a privacy perspective is something which is going to be really interesting. I think we can take one question from Shreyan and then we can move on to Karthik's question. The loot box concepts are really interesting, right? Because it is a virtual wallet sort of a thing which you have. It's like a winning thing. Now, typically the terms and conditions will govern your arrangement, but what happens if there is a breach, right? Now, if some other user kind of, you say that, okay, I'm giving you access to take 10 tokens, but actually 100 tokens are lost. It is fine to a certain extent where it's not quantifiable in terms of monetary terms, or you can get something equal to money. But the whole debate which is also happening in the virtual world is that our virtual assets properties in terms of which are akin to money or which are akin to value, and to what extent can they get protected. So disclaimers, yes, the developer or the platform can mitigate some amount of risk, but I'm sure the jurisprudence will evolve more and more. I think the second question which we have from Karthik, we will pick it up as we go along. But moving forward to what Inika said, right, the privacy concerns are there. So we've actually spoken a little bit about IP. We've spoken a little bit about privacy. I think the next interesting topic akin to both of these is liability. Now, liability from a legal perspective has a big genre. One is from a consumer protection perspective, one is a tortious vertical, the third could be a product liability. So there are various branches of liability when you talk about the virtual world. So let's start off probably a little bit from a consumer perspective. A lot of these platforms which are available, the AR, VR platforms, they are essentially for personal consumption. And usually they are paid services or it's a paid product. So to that extent, the person who's availing these services or a product would usually be deemed to be a consumer. Now, the whole question which arises in the VR AR world is to what extent is the developer or the company which is running the platform liable? Because as Inika also earlier mentioned, there's so much of simulation which is there. And there is so much of user enhancement which is there that the performance of the AR or the performance of the VR actually depends on how you behave or what sort of data you feed in. So in reality, the VR company say is giving you a particular form of a product, but the improvements happen basis how you have kind of interacted with it. So to that extent, if tomorrow something is going wrong with the product or is going wrong with the service, is the manufacturer or is the developer completely liable? Can there be a defense that no, we've given you like a standard form of product, but the liabilities arose because of your functionality and your user experience? Now, again, these things are not, very tested. They are still evolving. I think the second principle comes is in the virtual world. How do you kind of implicate the principle of Tausch's laws, right? Because first and foremost, is a virtual space actually a real space? So for example, somebody is entering into your virtual space. Can that be trespassing? Things like that. So, in the brick and mortar world, if you own a house, you own a property, if somebody comes on without your permission, yes, there is a legal right which you have. So in the virtual world, if you have a tangible space, and if something, or you have built your own space in the virtual world, can the thought of trespassing apply? Similarly, how will the principles of negligence work out, specifically when you're actually manufacturing a particular model, or you're playing a particular game? Is there a duty to care? Because most of these environments are also team led. So there could be a team from one jurisdiction playing and interacting with you from another jurisdiction. So is there some amount of duty of care towards the other participants? These principles of liability is always there, but which also brings me to a very interesting point, which is correlated to liability, is morality and ethics. Now, a lot of these games and a lot of these models which are used for entertainment at times tend to get obscene. They're kind of abusive. There was another game which was like a war game, which was banned in several parts of India a few years back. When Pokemon Go came in 15, 16, there were actual cases in terms of real life loss. So there is no standards of morality or ethics which applies, because at times humans do get influenced when they spend longer time on such mediums. But having said that, a lot of these principles are not settled. They are open. They will continue to evolve. But I'm sure we will have some sort of clarity and evolve jurisprudence as we go ahead. I think on that particular note, it may be good, if we can discuss a little bit about enforceability of these contracts which you actually sign up to, specifically, from a jurisdiction perspective, because users would be in multiple jurisdictions, they would be talking to each other, the developers would be in some other place. So probably, Inika, it would be great if you could just throw some general light on typical cross-border enforcement issues which may come up in such cases.
Thanks, Huzefa. So when we think about e-contracts follow the same general principles as traditional contracts do. So as long as there is an offer and there is an acceptance, an e-contract would generally be valid. Abhishek spoke about one exception in the event that a physical signature is needed. Then the Information Technology Act provides for e-signatures, which could replace that. And when he spoke about the assignment of copyright needing a physical signature and hence an e-signature, that is one exception. But with that exception, e-contracts are generally valid, which many of these AR, VR developers would rely on. And as I had mentioned earlier with the privacy concerns, the most common form of these e-contracts and where the legal issues would arise is the terms and conditions between the developer and the user for the app. And that being said, most of these terms and conditions are standard form agreements, and they would not be as consistently revised. So that's something that developers need to keep in mind, that these terms and conditions should be revised every time that there is a significant development in their game, in the technology, to be able to cover for all instances that could occur. So that being said, when it comes to dispute resolution, in these instances, it largely depends on the terms and conditions and on the contract itself, on what dispute resolution mechanism that contract provides for. So in the event the terms and conditions provide for arbitration, then the users would resort to arbitration. In the event that it blesses certain courts with jurisdiction, then those courts could be said to have jurisdiction over a dispute. But it isn't that black and white, and it is quite a gray area. As Huzefa was mentioning earlier, there could be some confusion. For example, if there is AR VR developers in the United States offering their product in India, and if we take the example of a user using a VR headset and getting injured in the process, and he's using it in Bombay, so which courts would have jurisdiction? Do you look at the contract, or would the courts in Bombay have jurisdiction because that's where the cause of action arose? So there are many questions that these kind of disputes can throw up, and it is quite a gray area, and all of these situations would have to be examined together. Another aspect that is important is the statute under which a user would want to claim an injury or damages or an offense, and whether that statute has extraterritorial jurisdiction. A good example is the Information Technology Act itself, which has extraterritorial jurisdiction to an offense committed by someone outside the country if the computer system involved in the offense is located inside India. So that is one example that we can keep in mind. And when it comes to the reciprocity of judgments, of awards, that depends on the relationship between the two governments. For example, if it's India and the United States in the same example, arbitration awards are enforceable, and there is reciprocity of arbitration awards, but not for court decisions. So that is another important consideration to be kept in mind.
Oh, thank you so much, Inika. I think another related question to all of this is also criminal sanctions. Again, this jurisprudence has not evolved much, but imagine by design you create something which is, extremely against public interest, so it's extremely violent, and indulging or being in a virtual, reality environment for that particular purpose may actually influence you in a destructive or in a negative way. So in those situations, can we kind of extend the criminal sanctions, the principles of abatement in such cases? Of course, any criminal sanctions, the underlying principle is intent and mens rea. But having said that, these sort of things will also get questionable when there are more and more offenses which kind of get committed basis a VR, AR environment. I think on this point, it may be probably good to pick up Karthik Tyagi's question. He asks us that does India Data Protection, the PDP bill, which is there, incorporate the concept of right to be forgotten? The answer to that is yes. The bill does have provisions of right to be forgotten, but the enforcement is subject to an order under the PDP bill. So the way it will unfold is that if you want to invoke your right to be forgotten vis-a-vis any particular entity who's collected your information, you need to approach the adjudication authority under the bill. Once they give you an order, then you take the order, you inform the person, and then you will be forgotten. So it's not a suo motu right. It actually depends on a formal order which is given by the adjudication officer. I think we have a couple of more questions, but we'll pick that as we move forward. I think the flow from an IP, from a data, from a enforceability, from a liability perspective, I think it has been spread out really well. But from a future perspective, right? I think the importance is that are there any government initiatives which are being undertaken? Are there any guidelines which has been undertaken by the Indian government, specifically in the AR, VR, MR technology? I think on this particular front, it may be good if Abhishek can throw some light on the same.
Sure, Huzefa. So just to, by nature of the industry itself, for AR, VR and MR itself, so the most common sort of industry in which these products are used is the gaming industry, where a lot of these applications are used by game developers, where they create a separate portal or a virtual reality that people can use for recreation. So when it comes to industries like this, and the government specifically passing guidelines or regulations dealing with this issue, there's not that much per se from the government side on regulating it or passing guidelines. And another reason also for this is this industry by itself is inherently self-regulatory, where they have a lot of industry associations and a lot of these developers come together and set out guidelines within themselves that they accept and agree as industry standards, which need to be sort of adhered to across the board by multiple developers when they're developing the product and preparing the actual product. But looking at a few steps that the Indian government has taken, so in the recent past, in the past year or so, the Niti Aayog has taken a few steps on this front, where one AI specific task force was set up by the Niti Aayog to sort of look into formulating detailed guidelines in India that deal with artificial intelligence and machine learning. Now, basis the committee that was set up, a detailed report also was issued by this task force, which sort of looked into the various forms of applicability in industries in which artificial intelligence and machine learning are actually sort of used, and how, regulation needs to be sort of developed on this front. And this report sort of delved further into actually providing specific definitions which can be used by regulators for something as such as artificial intelligence, or for even something along lines of machine learning as is used in AR and VR products. And going forward, even after this task force had come out with this report, the Ministry of Electronics and Information Technology in India has set up a separate sort of cell, a separate sort of center, which is basically a center of excellence for VR and AR, which is a linkage, or it's a joint project that's been sort of set up by the Indian government and the Indian Institute of Technology in Bhubaneswar. And what they're doing here, what this center is doing, is they brought together about a team of around 12 to 13 specific developers of AR and VR products, and they're allowing them to sort of pool in ideas together and bring out or develop specific products in a safe regulatory space, where this can be something that's comparable to a concept of a regulatory sandbox, where the center for excellence, how it's functioning is it's allowing developers in a safe space to sort of put in ideas, innovate, and come out with products, and then basis the final products that the center in itself comes out with. Using that as an example as to how the development happened, the intent is to form guidelines along these lines. Now, these are a few steps taken by the central government, but also there have been several steps taken by independent state governments in India as well to further, innovation and guidelines in this industry. And the sort of most prominent example is the state of Kerala, where the Kerala Startup Mission, which is a separate body set up by the Kerala state government, has also actively been looking to tie up and partner with several startups that are engaged in the AR and VR space in order to allow, provide them with funding and also help them with sort of getting more information in or data that they require to bring out and make sure the final product that they develop is developed as a whole. And what the Kerala government is doing in this case is that also they've announced incentives via the startup mission, where they're incentivizing startups to come in and carry out development with the help of the government. And again, similarly, the government is intending on using this development as a testing phase for bringing out, future guidelines and regulations. So these are just a broad overview of the few steps that have been taken so far by governments in India. So I think over back to you, Huzefa.
Great. I think this is very good, Abhishek, especially how you've jotted and enlisted the initiatives which have been taken by the government of India. I think we have a few more questions which have come up on the panel, but why don't we take them after we speak about a little bit on the tax front, and then at one go we can actually take these questions. We've spoken about legalities, we've spoken about liability, we've spoken about TOSHs, we've spoken about enforcement, and of course, we've spoken about the way forward too from a government perspective. I think one thing which we absolutely need to touch upon is that what are the tax considerations, right? These are such evolving radical models of technology, that the traditional rules of taxation may actually not apply, or there may need to be completely new principles of taxation. On this note, I would like to have my colleague Meyyappan, who's an expert on digital tax, to speak a little bit upon taxation of these models, and are there any new developments in India which would actually impact the functioning of these models?
Thanks, Huzefa. So on the digital tax front, there is a lot happening currently, even including in the last budget that was announced. We've also had some new taxes inserted after the budget announcement and before the Finance Act was passed. So very quickly to cover, there are a lot of issues that can potentially come up, and expanding digital taxation is something the government is clearly focusing on, and actually is taking a pioneering role in the world, almost making itself an outlier in this case by enacting very expansive digital taxes. So to quickly talk about the new tax that has been recently imposed, it's called the equalization levy. There was a version of this that was passed in 2016, which was targeting only online advertising services, but now it's expanded into a 2% tax on almost any digital service that is provided online by an offshore company. So if a foreign company is providing any digital service to a person resident in India, they are supposed to pay 2% on the income or the consideration that they receive. Additionally, they are also targeting advertising services being provided by a foreign company to a foreign customer if the advertising is targeting an Indian buyer at the end of the day. So this is also very expansive. There is no precedent of such an expansive tax being passed in the world today, and there are questions about its constitutionality also in terms of whether the parliament has the power to impose a tax on a transaction happening outside of India just on the basis that there are the target of the advertisements are people who are in India. But nevertheless, to just quickly get into the three categories you had spoken about, VR, AR, and MR, and see that give a example that's representative of a situation where this tax could be applicable. So when we are talking about video games in virtual reality, right? So if there is a offshore operator providing this game and through the internet, then the 2% levy will be applicable in such a situation. When it comes to AR, it's a very good sort of platform for advertising to come up in the future. In fact, the latest advertising products are talking about you wearing something like a Google Glass sort of a device, and depending on where you are, as Inika was saying, they have the data of your location, they know where you are. So the relevant advertisements start popping up depending on what you're looking at and what you're seeing. So in that kind of a situation, if there is a foreign advertiser who's targeting their services to you, like a restaurant recommendation app who's based abroad, and they are targeting a user ultimately in India, the equalization levy will cover these sort of transactions as well, even though the payment is being made by that restaurant recommendation app to a non-resident. The third thing is when we come to mixed reality, I mean, taking a situation where there could be like virtual meetings or board meetings going forward, right? Where all of them, instead of traveling, are sitting in with respective countries and the board members are taking a decision. There is a risk that apart from the companies that provide these services, the companies that use these services may also have they have to be careful when using these technologies because their place of effective management may actually change. So the company may, in some circumstances, there is a risk that they may be considered as having a tax residency in India, and that exposes their global incomes to a 40% tax in India. Some of the other things that can come up are, server PE issues, meaning if there is a server in India that is under the control of a foreign company providing a digital service, that can also create a tax exposure. This can sometimes happen in the form of CDNs or content delivery networks, which are basically used to increase the delivery of the speeds of the service. So those kind of issues can also crop up. And the other thing that the Indian government is trying to do is, as Inika said, there is a lot of data that is being collected in the provision of these services, which is required for the provision of these services as well. But from a tax perspective, they are trying to, the government is trying to say that more of the income earned by these foreign companies need to be attributed towards the data that is collected from India, and therefore more taxes have to be paid here. And lastly, there is another argument which the tax department repeatedly keeps bringing up, which is that instead of an online service being used by a customer in India, they try to categorize it as a royalty payment, which makes the consideration subject to a 10% tax. Because currently under the law, if you are earning business income and you don't have a physical presence or a permanent establishment, that income by a foreign company is not taxable. But they try to categorize it as a royalty, meaning that you're actually paying it as a license to use the underlying technology in these cases. So these sort of issues can still come up in the future. But the broad takeaway is that I think the focus is increasingly on taxing digital activities. And again, it's a very wide tax that India has passed.
No, thanks so much, Maya, on this. I think these insights are really great. I think let's move on to a few questions which we still haven't answered. I think the one which a couple of them still remain unanswered. One is from Karthik Tyagi. He talks about which models are being developed to incentivize users for monetizing of their data. I think I think the simplest model is that companies are not charging for their services, and that is a direct economic monetization benefit. But having said that, across the world, some companies are incentivizing users to give more and more data, whereby there are certain premium services which they are offering, or there are some loyalty or reward points. In fact, Facebook last year introduced something called as Viewpoint. It was like a retail marketplace survey app, whereby people who are using it and bases a certain a level of data and account user information reach, Facebook was actually sending money, rewarding consumers on those fronts. So these are the models which are being used in terms of monetization and economization of user data. But from an Indian perspective, I think the market is still evolving. I think, Karthik, I hope that answers your question. I think the last one, which is really interesting, is from Adam. He says that if he's using an existing product, which is say a BMW car, which makes an AR proof concept without specifically informing or taking permission from BMW, is it wrong or a violation? So what I understand, Adam, what you're trying to say is that if there is a AR VR environment which is using a BMW car, will that be wrong, assuming whatever disclaimers are there and BMW's permission has not been taken? I think this goes back to the concept of fair use, which I was talking about, right? The principles on which the developer, the company has developed the AR VR environment where the car is used. The first question will come is that what is the bona fide, in relation to using the BMW car? Second, more importantly, is that whether there is an intended sponsorship or endorsement which you are trying to make with BMW. Third, whether such use of the BMW car is likely to confuse or deceive the customer or the users vis-a-vis BMW. And lastly, is it detrimental to the image, or is it bringing any sort of disrepute to BMW? I think these are the conditions and circumstances which will need to be considered. To the extent, if you're not tipping off any of these, there could be an argument in terms of fair use, but it will be on a case-to-case basis, whether you've actually violated or not. It will need to understand the larger game and come to a conclusion on the same. I think we've actually answered most of the questions, and I think we are right on the dot as well. So on this note, I'll actually hand over the same to Devanshi, who's actually moderating our session. So over to you, Devanshi.
Yes, thank you so much, Huzefa, and thank you to all our panelists for the session today. A big thank you to all our participants who have joined into this call. I would just like to let all our participants know that we have a session lined up at 9 p.m. as well, titled Patent Issues in Indian Technology Sector. For all those interested, we'd love to have you all on the webinar at 9 p.m. And thank you once again for joining in today. You may now disconnect the lines.